Karen Read murder retrial just kicked off with day 1, and it seems pretty clear at this point that this will not be a mere repeat of season 1 of this trial. That's despite the fact that she is on trial for the same 3 charges as before: second-degree murder, manslaughter while operating a vehicle under the influence of alcohol, and leaving the scene of a collision causing personal injury and death. Now, I say season 1 like this is a TV show of some sort. Obviously, this is a real case with real people involved, and above all, it is a murder case. So there are serious real-life consequences to this trial, of course. But the Karen Read trial a year ago also proved that it has some of the most insane twists and turns in a trial that I've really ever seen. So I cannot help but think of the retrial as like season 2. Anyway, trial kicked off with opening statements and the start of the Commonwealth's case in chief with 2 witnesses called to the stand. And there was also something that we did not see in the first trial: clips of Karen Read's own words from the many interviews that she did leading up to the first trial. And I gotta say, until the defense comes out to do something to flip each and every one of these clips on their head, they are so far fairly damaging to Karen Read's case. Now, the defense had a stellar opening statement on day 1, but the Commonwealth has definitely come out swinging in their case in chief, and they have already landed what I think are some fairly big punches on day 1. Whether they end up making a difference at the end of this trial, of course, remains to be seen. Let's get into it. Okay, so before we dive in, I do want to say that in the first trial, I was live streaming every single minute of it and providing daily recaps. At the time, I also was pregnant with Legalbytes. And now Legalbytes is, well, a baby. So that means I am a bit less free to spend my time spending all of those hours doing everything for this trial. So I can't live stream it this time around, and I'm going to try to do as many recaps as I possibly can. I can't guarantee that I can recap every single day of this trial, and the recaps might come out slower than they did in trial 1. But really, I'm going to do my best to just try to give as much coverage of this trial as I can because I just can't stay away. So if you want more of this and you haven't done so already, be sure to hit the like button to boost it to the algorithm, and subscribe and hit notifications so you can know when the next one is out. Okay, with all that said, let's get into opening statements. If you watched season 1, you know that the lead prosecutor in that trial was Adam Lally. He's been demoted to second chair this time around in favor of Special Assistant District Attorney Hank Brennan. Brennan is most known for being on the defense team for the notorious mobster James Whitey Bulger when Bulger was on trial in 2013 for murder. Yeah, you know, the guy Johnny Depp played that one time. Anyway, Brennan is already proving to be an improvement over Lally. I'm sorry to say it about Lally, but it's true. It started with the opening statement. But before I talk about Brennan's opening statement, let me first say a quick word about opening statements generally. The purpose of the opening statement is to give a basic overview of what the case is about and what the jury can expect to see. It's basically a roadmap. It's one of the rare times that the attorneys on both sides are allowed to speak directly to the jurors, and it's crucial for setting the tone of the trial, the stage of the story, and for providing a framework into which the jurors are able to organize all of that information that they are about to be inundated with. So what you really want to see above all is both sides telling the story from their perspective. You don't necessarily want to see them get bogged down with too many details with names, times, and dates. Don't get me wrong, these things are important, especially those times around midnight, 2:30 a.m., 6 a.m. on January 29th, 2022. But you want the opening statement to be punctuated by those kind of details, because otherwise too many fine details start to look a little impressionistic, like a Van Gogh painting, and suddenly those details blend together into some other picture. And that's because the jury isn't quite ready for all that detail at the very beginning of the case. You've got to sort of ease them into it. But anyway, another thing that you might see is a theme that gets reinforced throughout every witness's testimony, starting with the opening statements. This is basically a concept that gets reinforced that supports that side's narrative. And it can serve as an easy callback for that side to hint at their overall theory and the overall support for their case. Okay, so let's talk about the Commonwealth's opening statement in particular. Brennan started the story at 6:04 a.m. on the morning of January 29th, 2022, where he focused on how John O'Keefe's body was found in the snow that morning. He talked about how firefighter Nuttall says that Karen Read told him, "I hit him, I hit him, I hit him." Now, whether or not she actually said that is a huge sticking point in this trial for both sides, because of course, this sounds like to any reasonable person walking freshly into this case, like an admission. Anyway, Brennan also told the jury that they'll see evidence that Karen and John had gone out on the night of January 28th and that they had been drinking heavily for hours. Brennan also said their relationship was privately on the rocks and that they had gotten into a fight that night. Then he said that after they left the bar to go to the home of the Albert family, she let John out of the car, started to drive away, then stopped before reversing up to 75% acceleration and hit him with her right rear bumper before taking off again. And this leads to the main theme of Brennan's opening statement. The data, the science, the facts will back all of this up. Overall, this was a pretty straightforward opening, fairly well done, and I think it didn't get too bogged down in the details in the same way that Lally's did in the first trial. And the thing I remembered most from the opening statement was Brennan presenting to the jury that data, science, facts will all show that Karen Reed killed John O'Keefe with her car. He pointed to John's GPS Waze data, Karen's car data, which he referred to as a black box, like what you hear about with plane crashes, and something new that we didn't hear from the first trial, data about the temperature of John's phone. Now, having watched the first trial, I do find that interesting because there, the entire investigation turned out to be a complete farce and what should be an embarrassment to law enforcement everywhere. And the Commonwealth's accident reconstructionist, whose testimony was crucial to connecting Karen's car with John's body, was, in my opinion, equally pathetic. So it'll be interesting to see how the Commonwealth goes about all of this time around, to see if they can either give a total remodeling of their case or if they're going to end up just basically putting lipstick on a pig. We'll see as the case progresses. Anyway, one final thing about Brennan's opening statement that I want to talk about. Towards the end of it, he played a clip of one of Karen Reed's many sit-down interviews. This is what he played.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Now here, she's questioning whether she could have hit him. She's not stating that she did indeed hit him. So it's not quite an admission, but it's not a good look when the defendant herself seems to be waffling as to whether or not this may have happened. Also, this does seem to suggest that she did in fact drink enough the night before that she could have, in some cloud of drunkenness, hit him, even if by accident. In the first trial, I remember saying that at most, what the Commonwealth seemed to have, at least, was alcohol testing from many hours after the alleged incident, which requires quibbling over mathematical analysis to see when she was intoxicated, to what extent, at which hour, etc. And the other thing that the Commonwealth seemed to have as to this issue as to whether or not she was drunk for the purposes of drunk driving was surveillance footage of Karen ordering, holding, and drinking from glasses of clear liquid. But it seemed that no one could really be certain as to what it was she was drinking, to include the bartender who testified, by the way. And there wasn't any receipt for their bar charges introduced so that anyone could, for example, show that a clear liquid like vodka or gin was on their bill. So for all we really could certainly tell, it could have been water that she was drinking. So her suggestion in this clip that she's entertained the thought that she could have hit someone in a night of drunkenness feels like the most damaging part of this clip because it does seem to reinforce the idea that she definitely was drinking that night. However, then Alan Jackson got up to deliver the defense opening statement. And he did what Alan Jackson does, which is dazzle. Full disclosure, if you didn't see my coverage of season 1 of this trial, I have become a huge Alan Jackson fan because I love his trial presentation style, and I think that he's really a brilliant lawyer. He is great at listening on his feet and catching witnesses on cross-examination on the tiniest details and shredding them to pieces with inconsistencies. And he delivers a great opening and closing. And this opening statement was no exception. So remember how I just said that Karen's statement in that opening clip that was played was damaging because it sounds like she more or less was admitting to having drunk enough the night before to have been driving drunk? Well, in Jackson's opening, at one point he pointed out that she was talking about this possibility of, could I hit him in my drunkenness, not overnight, but the next morning after finding his body. Essentially, this was her trying to make sense of this whole situation. And this might make a difference to the jury by showing an early example of the Commonwealth showing one thing and then the defense getting up and turning it on its head by widening the scope, so to speak, so that the jury has a bigger picture contextually, making the whole picture look a little bit different. But more importantly, in the first 30 seconds of his opening, he showed immediately why that probably doesn't even matter anyway.
The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe.
This is huge because it means who cares how much Karen drank the night before if the defense can show that there is no physical possibility that her car collided with John's body. Whether or not the collision actually occurred is a linchpin element that the prosecution needs to prove for every single charge. If the defense can destroy that possibility, they secure an acquittal for Karen on all charges. And like I said earlier, if the evidence is basically the same as the first trial and the experts are more or less the same as well, the Commonwealth might have a major uphill battle using the science, data, and facts that Brennan just told the jury was basically the most important thing in this trial. Anyway, getting back to Jackson's opening, he then spent most of his opening statement talking about the insanely flawed investigation and how Trooper Michael Proctor's grimy fingerprints are all over it. And he told the jury why this is a huge problem, because Proctor's investigation as the chief investigator of this case was so bad, so corrupt, that he got fired from the Massachusetts State Police over it. That is such an eye-opener for anyone that is new to this case, and Jackson did an amazing job of hammering that home. Proctor is a bad guy who was looking to protect the homeowner on whose lawn John O'Keefe's body was found because the homeowner is a Boston cop. And not to mention, Proctor is also like super best friends with the Albert family, apparently, the owners of the home where John was found. So now from the defense perspective, this is a story not of drunken anger resulting from a shaky relationship. This is a story of police corruption intended to protect a member of the so-called blue wall, as Jackson called it, from those repercussions, and a woman who was quickly framed to take the fall for it. And I also want to insert something here that I found interesting. You know, right before opening statements, the judge gives instructions to the jury for how to go about this whole trial. For example, no talking with one another about the trial until deliberations, and also things like the importance of not forming an opinion until the end of the trial. Judge Cannone also talked about implicit bias.
One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then.
Now, the judge in any case is the main person in the room that jurors typically will trust. The lawyers are all obviously hired guns, and the expert witnesses are also hired guns, and many of the witnesses will come from a particular perspective that can typically be sniffed out. But the judge is someone that jurors will typically trust to talk to them straight. So assuming that they're paying attention at this point in the trial, which is pretty likely because it's early on, their attention is fresh, etc., keep in mind that they're hearing from this person that they trust probably the most in the room talk about how a rush to judgment is a bad thing and something that jurors should avoid in their very task. And so now let's go back to Jackson's opening where he says this.
What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking.
If the jurors were paying attention, this might stick out to them because the judge just told them not to rush to judgment. And now the defense is telling them, hey-o, this is exactly what Trooper Proctor and the rest of the cops investigating this case did. Maybe it's a nugget that just stuck out to me, and maybe I'm making a bigger deal out of it than it's worth, but I figured it was worth noting. Anyway, Jackson then went on and talked about the connections between the Alberts and Proctor and Brian Higgins and all these other people. And Jackson also said something new that we didn't hear in the first trial. He said that the evidence would show that John had to have been injured somewhere warm and then moved to somewhere cold. He referred to medical evidence that shows John never got hypothermia despite supposedly getting hit by a car in the snow. And he referred to the same cell phone temperature data that Brennan mentioned in his opening. Jackson said it supports his idea that John was injured someplace warm, then brought to the cold. Jackson also talked about the butt dials we learned about in the first trial and Jen McCabe's 2:27 a.m. Google search Haas long to die in cold. And he also talked about Karen's panic when John never came home, which built up higher and higher as the hours progressed until she found him in the snow on the Alberts' front lawn. But what stuck out to me most from Jackson's opening were these 2 points. First, he said the evidence will show that there was no collision. As I said, super important point for the defense. And second, he said that Trooper Michael Proctor is a cancer that cannot be excised from this case, and he's tainted absolutely every part of this investigation from start to finish, and that casts a shadow over the Commonwealth's entire case. And if the defense succeeds in introducing evidence that backs that up, that is also huge for the defense. Okay, so that's the opening statements. Let's talk about the witnesses. The prosecution's first witness was firefighter Timothy Nuttall. He's a paramedic and was one of the very first people to arrive on the scene on the morning of January 29th, 2022, after 911 was called when John's body was found on the Alberts' front lawn. He talked about their efforts to revive John by giving him CPR and breathing support, all while trying to warm his body up. Now, thankfully, Brennan skipped this part in Nuttall's testimony where the Commonwealth was previously asking about every single turn that they took from the fire station to 34 Fairview Road. In the first trial, Lally asked every single first responder for that as if it somehow mattered in the trial, and I think it really hurt the Commonwealth's case because it unnecessarily taxed the attention of the jury. Not to mention, it started to feel like a Massachusetts version of the SNL sketch The Californians.
I know a shortcut through El Segundo. Take the 105 West and exit on Culver. When you see the Zanko chicken on the left, turn right. Take Venice and follow it all the way down. Then you're in Marina del Rey.
But anyway, the most important part of Nuttall's testimony was where he says that he asked Karen Reed about John and his history, and she responded by saying, I hit him, I hit him, I hit him. And then he said he overheard her talking to other people where he says that she also told them I hit him. The Commonwealth even pulled up dash cam footage this time around so that Nuttall could show the jury the moment that he says Karen made this statement to him. Now on cross-examination, Jackson got up and I think shredded Nuttall's testimony, basically, just like he did a year ago. You see, the credibility of every single witness is always at issue. And jurors are going to be looking for things like bias, memory issues, perception issues from the incident itself. So if a witness appears to have some issues with their memory of the events over time, the jurors might discount the weight of their testimony. And here, Nuttall had some inconsistencies with his prior testimony. First of all, none of the reports that were taken around the time of these events back in 2022 mentioned Nuttall telling anyone else that Karen had told him, I hit him, I hit him, I hit him. And that includes the report written on February 8th, 2022 by the defense's boogeyman, Trooper Michael Proctor. So we see the theme of the bad man Trooper Proctor already showing up this early in the trial in Nuttall's testimony. And this is going to be important when the defense eventually blows the lid on all of Proctor's sins later on in this trial. And that's because it goes to this overall point that the defense is making that Trooper Michael Proctor spoiled the entire investigation that the Commonwealth is resting this whole trial on. Anyway, Jackson also pointed out that when Nuttall testified a year ago and for the grand jury hearing before that, he said that Karen said, I hit him twice versus 3 times. Nuttall admitted on cross that this is an inconsistency, but he said, my memory is better now than it was a year ago. Which, if you're at all familiar with psychology and how the brain works, you know that typically that's not at all how it works. But he was so confident in his memory, and I think that ultimately that is a big problem for Nuttall and for the Commonwealth. It's a problem for the Commonwealth because they did really nothing to take the sting out of his memory issues and otherwise his inconsistencies. And by that I mean they didn't bring it up on direct examination and waited for the defense to bring it up first. This makes it seem like they're maybe hiding from that and really don't want to talk about it, and just, like I said, they're waiting for the defense to bring it up. Anyway, Jackson highlighted these memory issues even further with another huge inconsistency in Nuttall's memory of the events from that morning. You see, previously Nuttall had testified that John O'Keefe was wearing weather-appropriate clothing, meaning clothing that was appropriate for the blizzard that had hit the night that John was out. He even testified to seeing John had been wearing a big puffy jacket, meaning one with down in it, definitely weather appropriate. But when Nuttall testified a year ago, he was shown that John had nothing like that on him at all. Instead, he was wearing an orange t-shirt and a gray long sleeve shirt over it. Hardly weather appropriate for a blizzard. Now, people can say that a person can misremember one thing, but remember another thing clearly, and that is absolutely true. But the point is, he was very confident about his memory across the board, which means that anyone looking at this testimony reasonably might look at that and say, I can't trust his confidence in his memory because he's clearly very, very wrong about this other thing that is a glaring issue. That, compounded with the fact that he went from saying, Karen said I hit him 2 times, versus now saying, Karen said I hit him 3 times. It just speaks to his overconfidence in his what looks to be a fault in memory. And to me personally, this is reason to discredit his testimony. And the fact that he's the Commonwealth's first witness doesn't really speak all that well for the strength of their case. That's because there's a primacy and recency effect. Juries will tend to remember most the testimony that came first and the testimony that came last. The stuff that gets pushed into the middle tends to get a little bit fuzzy on the edges. So having your first witness not really turn out to be that great is, I don't know, it's not all that helpful to the Commonwealth, to be honest. Okay, so then the Commonwealth called their next witness, but before they did, they played for the jury another clip from one of Karen Reed's interviews. And something tells me this is going to be a pattern that the Commonwealth chooses to use in between witnesses. It has me wondering whether they're trying to goad Karen into actually deciding to testify because she didn't testify in the first trial. And I don't know, based on what I understand about her personality, it might actually work. I'm sure that there's some level of her that is really itching to talk, and seeing these clips being taken out of context again and again, potentially out of context, I should say, again and again, it might be really, really, really bugging her. But anyway, this particular clip was much worse than what the Commonwealth played during their opening statement. Here it is.
Or did they come back to you or something? I mean, how much do you remember?
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember it on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Now, there's a lot in this clip. At one moment, she says she knew that she couldn't have said that she hit him. But then she almost immediately thereafter says, I mean, I know I said I hit him, but did I really say it as many times as law enforcement says I did? And that is damaging to Karen Reed's case because it sounds like she's admitting to saying I hit him when the defense is putting in all this work to show that she didn't say it. So this could be a problem for the defense if they are not successful in reframing or recontextualizing it, for example, by widening the scope of this interview to show that it is, out of context and that there is a proper context that completely shifts how to understand the things that she said. Knowing what I know about the defense team, I am sure that the defense has some kind of strategy for dealing with this head on. But until they do, this is the kind of thing that is going to sit with the jury. And really, this is another example of why I think this trial is going to be very different than the first one. Okay. On to the final witness of the day. The Commonwealth's second witness was Kerry Roberts. She was a longtime friend of John O'Keefe all the way back to high school, and she was with Karen Reed when they went out into the blizzard on the morning of January 29th, 2022 to look for John. She says that the night before, she had gone out to dinner and bowling with her family. She then went home and her husband went out to McCarthy's bar to meet with John. Later, she says that her husband came back around 10 p.m.-ish. It hadn't started snowing yet. Then they go to bed, and the next morning she wakes up to a 5 a.m. phone call from Karen. When she picks up, Karen screams, "Kerry, Kerry, Kerry, John's dead." And then Karen hangs up. Kerry tries calling Karen back and somehow the two reconnect. Karen then tells her John never came back home that night and says, "I think he got hit by a plow. We drank so much, I don't really remember anything." Then Karen said that she wanted to go looking for him and also said, "I'm going to drive to your house. Would you drive my car?" Kerry then calls local hospitals to see if anyone got brought in after getting hit by a snowplow. She says that she also called the emergency line, which was recorded, and that recording was played for the jury. Then after a bit, Kerry says that Karen did not arrive at her house, so Kerry called Karen again, and Karen said that she was at Jen McCabe's house. Jen McCabe is the sister of Nicole Albert, who owned 34 Fairview Road at the time of this whole incident, along with her husband, Brian Albert. And this, of course, is where John's body was found. Anyway, Karen says that she's at Jen's house for some reason. Kerry then goes to Jen's house to meet up with him, and they all get in the car to look for John. First, they go to the house on Meadows Avenue, John's house. When they get there, Kerry says that Karen shows Kerry and Jen her taillight. This was after Kerry says that Karen was talking about how her taillight was cracked and had a piece missing from it. Now, it is interesting that Kerry says that there was a piece missing from it because later Trooper Proctor and the other police investigators apparently found 46 pieces of taillight at 34 Fairview Road, supposedly, if you believe the Commonwealth. How much damage various people throughout this trial saw to this taillight and when they saw that damage is going to be a very important part of this trial because Jackson talked in his opening about the ring footage in John O'Keefe's driveway that he says shows the moment that Karen cracked her taillight by colliding with another parked car. And he says that all of those other 46 pieces of taillight were basically planted by Trooper Proctor. Anyway, after they didn't find John at Meadows Avenue, Kerry says that they went to the Albert home at 34 Fairview Road. Kerry said that as they were driving, she was looking left and right and really couldn't see anything. She said it was dark out and it was snowing really heavily, so visibility was really, really low. She said that Karen was in the back seat, basically sitting between the two, kind of popping forward. There was apparently a mention of Bella's mom. Bella is a school friend of John's niece. If you're not familiar, John's niece and nephew lived with John ever since their parents tragically died, like within a year of each other, just a couple years before this incident or somewhere around there. Relatively recently is what I mean. Anyway, somehow Bella's mom came up and Karen said something like, "She never liked me." The Commonwealth brings this up because they want to present to the jury that Karen was jealous of Bella's mom because Bella's mom had previously dated John. And that goes towards showing that Karen and John had these major cracks in their relationship, fueled in part by Karen's jealousy. Anyway, then Kerry says that Karen started kicking and screaming, shouting, there he is, and she ran out of the car into the snow. Kerry says that she ran right towards a mound of snow, which was where John was ultimately found. The Commonwealth is definitely suggesting here that Kerry couldn't see anything to be able to see where John was, and that it was weird that Karen was able to pick him out like that. That's because the Commonwealth wants to present that Karen knew where he was because she had killed him. She had left him to die in the snow there the night before. And that's basically where the testimony left off. Kerry Roberts' testimony will continue on day 2, where we'll also look forward to her cross-examination. I will say that just like she did in the first trial, she comes across fairly well in direct examination. I don't remember her cross being particularly damaging for her testimony like it was for some of the other so-called friend witnesses like Jen McCabe, but we'll see what happens on day 2. Anyway, that's what I've got. What do you think so far? If you've been watching the testimony, is there something important that you think maybe I've missed? Let me know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next video.